Hello friends, I hope all of you are doing well. I am CMA Sridhar Akhula and this is Finance MCQ channel. Friends, in today's video we will cover some important provisions related to Chapter 27 of Companies Act 2013, which deals with National Company Law Tribunal and Appellate Tribunal. So friends, the provisions related to the Constitution of National Company Law Tribunal is provided under Section 408 of Companies Act 2013. So friends, the central government shall by notification constitute a tribunal to be known as National Company Law Tribunal. And friends, this National Company Law Tribunal will constitute of president, judicial and technical members. And friends, as far as qualification considered, we'll have to study section 409 of the Act. So friends, for president, the person should be or should have been a judge of High Court for 5 years. And for friends, judicial members, the person should be or should have been a judge of a High Court, or friends, the person should be or should have been a district judge for at least 5 years. And friends, even a practicing advocate of not less than 10 years will also be eligible for appointment as judicial members. And friends, as far as technical member is considered, the person should be a member of the Indian Corporate Law Service or Indian Legal Service for 15 years. And friends, even practicing chartered accountants, cost accountants or company secretary having not less than 15 years of practice are eligible for applying to technical members. And even friends, a person having special knowledge and professional experience of not less than 15 years in industrial finance, industrial management, industrial reconstruction, investment and accountancy will also be eligible for appointment as technical member of the National Company Law Tribunal. Now friends, even the presiding officer of a labor court, tribunal or national tribunal constituted under the Industrial Disputes Act 1947 holding the post for at least 5 years will also be eligible for appointment as technical members. Now friends, let's move on and study the provisions related to Constitution of National Company Law Appellate Tribunal as given under section 410. So friends, here again the central government shall by notification constitute an appellate tribunal to be known as National Company Law Appellate Tribunal. So friends, here the National Company Law Appellate Tribunal will comprise of chairperson, judicial members and technical members. So friends, remember that in case of NCLT, that is National Company Law Tribunal, the presiding officer was called as president, friends. But here in case of NCLAT, that is or National Company Law Appellate Tribunal, the presiding officer is called a chairman. Further friends, there is a restriction of total members in case of NCLAT, that is 11. Now friends, let's study the qualifications prescribed for the chairperson, judicial and technical members as given under section 411 of the Act. So friends, for the chairperson, the person who is or has been the judge of a Supreme Court or the Chief Justice of High Court will be eligible. And for the judicial member, friends, the person should be a judge of a High Court or is a judicial member of the tribunal, that is National Company Law Tribunal for 5 years. And friends, as far as technical member is considered, the person should have special knowledge and professional experience of not less than 25 years in industrial finance, industrial management, industrial reconstruction, investment and accountancy. And friends, National Company Law Tribunal and National Company Law Tribunal will replace Company Law Board and Board of Industrial and Financial Reconstruction with effect from June 1, 2016 after their constitution by central government. And friends, for your knowledge, please note that the president of NCLT currently is Chief Justice Retired Shri M.M. Kumar, while the chairperson of NCLAT is Justice Bansi Lal Bhatt. Now friends, let's move on and study the provisions related to terms of office of NCLT as given under section 413. Now friends, the president and every other member of the tribunal shall hold office as such for the term of 5 years from the date on which he enters upon the office, and they will also be eligible for reappointment for a further time of 5 years. And friends, the maximum age of holding office in case of president would be 67 years, while in case of other members it will be 65 years. And friends, further that a person who has not completed 50 years of age shall not be eligible to be appointed as the member of NCLT. Moving on. Now friends, as far as the terms of office is considered with reference to NCLAT, again the tenure for the members and the chairperson will be 5 years, and they are also eligible for reappointment of another term of 5 years, similarly as in case of NCLT. Now friends, as far as maximum age of holding office is considered, for the chairperson it is 75 years, while for other member it is 67 years. Now friends, remember that in case of NCLT, the maximum age for the presiding officer was 67 years, while for other members it is 65 years. And friends, again, no person who has not completed the age of 50 years will be eligible to be appointed as member, similarly as in case of NCLT. Now friends, let's move on and study the provisions related to resignation of members as given under section 416 of the Act. So friends, those members who wish to resign from NCLT or NCLAT will have to submit their resignation to the central government by notice in writing. And friends, there is a condition. Friends, those resigning members will have to continue to hold office till the earliest of expiry of 3 months from the date of receipt of notice by the central government, or friends, till the successor is appointed or till the expiry of his term at the office. Now friends, let's study the provision related to removal of members as given under section 417. So friends, the members can be removed by central government, and this can be done by after consulting the Chief Justice of India. And friends, as far as the other conditions are considered, the person should have been adjudged as insolvent or has been convicted of an offence which is in the opinion of central government involves moral turpitude. So friends, moral turpitude is a phrase used in criminal law to describe conduct that is considered contrary to community standards of justice, honesty or good morale. Now friends, even when he has become physically or mentally incapable of acting as president, the chairperson or member, or friends, when he has acquired such financial or other interest that is likely to prejudicially affect his functions, or friends, he has abused his position so as to render his continuance to the office prejudicial to the public interest. So friends, in all these cases, the members can be removed by central government. Moving on. Now friends, let's study the provisions related to benches of tribunal as given under section 419 of the Companies Act. So friends, the benches of the tribunal will be constituted by central government by notification. So friends, there will be a principal bench which will be at New Delhi, and this will be presided by the president. And friends, the powers of the tribunal shall be exercised by various benches that is spread across India. And friends, this bench will constitute of 2 members. One of them will be judicial member while the other will be technical member. So friends, at present there are total 16 benches spread across India. Moving on. Now friends, let's study the provisions related to orders of the tribunal as given under section 420. So friends, the tribunal may, after giving the parties to any proceedings before it a reasonable opportunity of being heard, may pass such orders as it thinks fit. And friends, the tribunal shall send a copy of every orders passed under this section to all the parties considered. Further friends, the tribunal may at any time within 2 years from the date of passing the order can rectify its orders. And friends, this can be done only in case if there is a mistake that is apparent from records. And friends, this can be done only when it is brought to the notice of the tribunal by the parties concerned. And friends, however, there is an exception. If there is already a pending appeal against the order, then in that case the tribunal is not allowed to rectify its own order. Now friends, let's study the provisions related to appeal of orders of the tribunal as given under section 421. Now friends, any person aggrieved by an order of the tribunal may file an appeal to the appellate tribunal, that is National Company Law Appellate Tribunal. And friends, no appeal in this section can be filed to appellate tribunal if the order has been passed by the tribunal with the consent of all parties. Further friends, there is a time limit to file the appeal. So friends, the appeal has to be filed within a period of 45 days from the date on which the copy of the order is made available to the person aggrieved. Further friends, this time limit can be extended to the further period of not exceeding 45 days if the appellate tribunal is satisfied that the appellant was prevented by sufficient cause for filing the appeal within that period. Now friends, Here again, the appellate tribunal shall send a copy of every order made by it to the tribunal and all the parties to the appeal. Now friends, let's move on and study the provisions related to section 422, which deals with expeditious disposal by tribunal and appellate tribunal. So friends, every application or petition presented before the tribunal and every appeal filed before the appellate tribunal shall be dealt by them in an expeditious manner within 3 months from the date of its presentation before the tribunal or filing the appeal before the appellate tribunal. However, there is an exception where an application or any petition or appeal is not disposed of within the prescribed specified time, that is 3 months, by the tribunal and appellate tribunal. They will have to record the same in writing, and if the president or the chairperson, as the case may be, after taking into account the reasons so recorded, might extend the period to a maximum of further 90 days. Now friends, let's move on and study section 423, which deals with appeal to Supreme Court. So friends, any person aggrieved by an order of the appellate tribunal may file an appeal to the Supreme Court, and friend, this has to be filed within 60 days from the date of receipt of the order of the appellate tribunal, friends. And friend, this can be filed only when there is a question of law arising out of such order. So friends, question of law involves the interpretation of law, and that must be answered by applying relevant legal principles by Supreme Court. And friends, again there is an exception where the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period of 60 days, it can allow it to be filed within a period exceeding the 60 days. So friends, with this we conclude today's video, where we have covered important provisions of chapter 27, which deals with National Company Law Tribunal and National Company Law Appellate Tribunal. So I hope the video was useful. Friends, for more practice of MCQs on this topic, please visit financemcq.in, where the entire SEBI grade exam technical syllabus is covered in MCQ format. Friends, here 2000 plus subject wise, topic wise MCQ questions are presented for you to practice. Friends, explanation are also added for correct answers wherever required. So friends, apart from this, there are 25 test series covering the technical syllabus for more and more practice. So friends, do visit financemcq.in and practice your technical syllabus well. And friends, don't forget that this technical syllabus is having 100 marks in phase 1 and is also having 2/3 weightage in phase 2 of your SEBI grade exam. So friends, this technical syllabus is very important for your selection. So friends, that's all for today. We will go through some more insight into the topic tomorrow. Till then, thank you very much for watching. Take care and goodbye. And don't forget to like, share and subscribe.